Good day. Today's proceedings will now commence. Please switch on your cameras and unmute your microphone.
Registrar, just call the matter.
Calling the matter, application SCQ 22 of 2021, application by Mr. Arthur Fraser to cross-examine Mr. Matuka, Mr. Njenje, Mr. Sheikh, Mr. Mfumadi, Mr. Chafta, Mr. Dindwe, and Mr. Y.
Thank you. Who appears?
Chair, I'm appearing for Mr. Fraser in these proceedings. And good afternoon, Chair.
Good afternoon, Mrs. Kakane. Thank you. Is there any other appearance?
I appear with Mr. Mabuza, who's also here with me.
Yes, okay, all right.
And Mr. Fraser himself.
Okay, no, that's all right. I'm going to deliver my ruling and the reasons, but the typed ruling will not be immediately available, but should be available tomorrow. But I'm going to read the ruling. The applicant, Mr. Arthur Fraser, lodged an application with the Secretary of the Commission on the 20th April 2021 for leave to cross-examine certain witnesses who had testified before the Commission or deposed to affidavits or both. Those witnesses were Ambassador Mzuvukile Maqetuga, Mr. Gibson Lizo Njenje, Ambassador Riaz Mo Sheikh, Dr. Folisani Sydney Mufamadi, Mr. Loiso Jafta, Mr. Setloma Maru, Isaac Dintwe, and Mr. Y, which is a pseudonym. One second. I think we don't need to put them on the spot all the time. Mrs. Kakan, I'm sorry, I'm interrupting the delivery. Are you happy to be on the screen all the time because you don't need to? Oh, you are not, you are muted.
Yeah, I would like to disappear from the screen and just watch you.
Yeah, okay. Do that. Okay, thank you, Mrs. Kaka. Okay, all right. And then done. Okay, thank you. I'm going to then proceed from paragraph 2. The applicant's application consisted of a notice of motion, a founding affidavit, and 2 unsigned statements. The first one of those statements is marked AF1, and the second one F2. to the second one, his application before the Commission that he had lodged with the Secretary of the Commission on the 9th of March 2021 for an order effectively compelling the Minister of State Security, the Director General of the State Security Agency, and the State Security Agency to furnish him with a long list of documents about which I will say more later. The applicant's statement marked AF1 is a statement that is said to be aimed at responding to the evidence given to the Commission by the witnesses that the applicant seeks leave to cross-examine. That statement is about 208 pages. The statement marked AF2 is said to be the applicant's response to the report of the high-level review panel that was chaired by Dr. Mufamadi in regard to the State Security Agency and its functioning. The application for an order compelling the SSA to provide the applicant with certain documents was about 159 pages. From the above, it would be realized that the applicant has furnished the Commission with statements and annexures amounting to about 447 pages. The applicant did not serve his application for leave to cross-examine on the witnesses he sought to cross-examine. In considering the applicant's application for leave to cross-examine witnesses, it is necessary to first outline the background against which that application should be decided. That background emerges from the applicant's application, his application for an order compelling the Minister of State Security, the Director General of the State Security Agency, and the State Security Agency to furnish him with certain documents, the transcript of the proceedings of the Commission on the morning of 14 April 2021, an affidavit deposed to by Mr. Frank Dutton, another affidavit deposed to by Mr. Patrick Mlambo, a letter from the Secretary of the Commission to the applicant's attorney, and the State Security Agency, dated 17 June 2021, and the response to that letter from the State Attorney representing the State Security Agency, and the applicant's affidavit deposed to on 22 November 2021. Reference will be made to the applicant's application relating to documents because the applicant said in his affidavit for leave to cross-examine that his statement to the Commission was incomplete without the documents he sought from the State Security Agency. The affidavit of Mr. Frank Dutton and Mr. Mlambo, as well as the transcript of the Commission's proceedings of 14 April 2021 were furnished to the applicant, and he was informed that the purpose of furnishing them to him was to enable him to deal with them by way of an affidavit should they be taken into account in deciding his application for leave to cross-examine. The applicant asked for an extension of time to deliver his affidavit, and he was granted such extension. He subsequently delivered an affidavit in terms of which he made certain allegations against the Commission and the Chairperson of the Commission. In the written submissions prepared by the applicant's counsel, the applicant's counsel refers to what he said or announced when he appeared before the Commission on the 20th July 2020. He also attached to his written submissions the transcript of the proceedings of the Commission on the morning of that day, insofar as they relate to the announcement he made publicly on behalf of the applicant. It seems to me that what the Applicants Council announced on that day publicly is a good point at which to start the background to the applicant's application for leave to cross-examine. This is what the Applicants Council announced, and I quote, "Ordinarily, Mr. Fraser would have liked to die with the secrets he is going to have to disclose to these proceedings. But it is only because he has been accused of treason that he reluctantly comes here. And he comes here, Chair, to complete your picture of this thing called state capture. To complete it because what the Chair was told, at least from the intelligence point of view, which is not something that ordinarily should be done at a place like this. His evidence is going to be important because basically he's going to complete the picture. Because unlike many other witnesses, he's going to have to share the secrets with the Chair relating not just to those who were in the administrative arm of government. He will have to complete this by doing something he reluctantly does, to tell the Chair about things that relate to the President or the presidents of this country, past and present, that relates to judges, that relates to parliamentarians. So those three arms, because the Chair will have completed that when he knows what has been happening there. As I said, I have advised him not to because he signed an oath. He approved the applicant's attorney on 5 August 2020 with that request. Mr. Mlambo says in his affidavit that the applicant's attorney not only rejected the approach, but he was rude and disrespectful to him. Mr. Mlambo says he subsequently reported this to Mr. Frank Dutton. Dutton then sent an email on the 5th August 2020 to the head of the Commission's legal team, Advocate P.J. Pretorius SC, and the head of the Commission's investigation team, Mr. T. Nombembe. The email from Mr. Dutton, dated 5 August 2020, to Mr. Pretorius and Mr. Nombembe, read as follows, and I quote, "Dear Paul and Terence, I asked Pat to phone Fraser's lawyer and refer him to the statements that Fraser would lay bare to the Commission, secrets that relate to presidents and judges. Further, that should his client wish to open a communication with the Commission, we would facilitate this. The lawyer took exception to this and expressed anger at our approach. Very clearly, according to the lawyer, Fraser does not wish to engage with us, but would use their own channels and methods. An interview with Fraser is therefore not on the cards. Regards, Frank," close quotes. The applicant has said that he was not aware of any conversation that his then attorney may have had with Mr. Patrick Mlambo on 5 August 2020, but he says that he had not told his attorney that he did not want to engage with the Commission. Apparently, the applicant's then attorney subsequently passed on. Mr. Mlambo has confirmed in his affidavit that he did speak to the applicant's attorney of the time, and the latter's response was as reflected in Mr. Dutton's email of 5 August 2020, addressed to Mr. Paul Pretorius, the head of the Commission's legal team, and Mr. Nombembe, 5 August 2020. The applicant's then attorney wrote to the State Security Agency and requested to be furnished with a variety of documents which he said he needed in order to prepare a statement to the Commission. That the applicant's attorney would on 5 August 2020 have written a letter or email to the State Security Agency asking for documents which he said he needed in order to deal with evidence led before the Commission is strange, because on Mr. Mlambo's version, that is the day on which the applicant's attorney rejected the Commission's approach to interview the applicant. The applicant's attorney said that the applicant needed those documents in order to deal with allegations made against him by certain witnesses who testified before the Commission. By way of a letter dated 23 August 2020, but sent on 21 September 2020, the Acting Director General of State Security, who was Mr. Loiso Jafta at the time, as I understand the position, responded to the applicant's attorney's letter and indicated that the State Security Agency was prepared to give him documents that were relevant to the allegations made against him in the Commission and relevant to the work of the Commission that could be given to him without being in breach of the law. Furthermore, the then Acting Director General invited the applicant in that letter to meet with him to discuss the matter and indicated that he would be prepared to expedite the process. That the Acting Director General of the State Security Agency had extended this invitation to the applicant as far back as September 2020 emerged from the answering affidavit deposed to by Mr. Simanga, the Acting Director General, as at April 2020, which was filed to oppose the applicant's application to compel the SSA to give the applicant the documents he wanted. By way of a letter dated 4 August 2020, addressed to the Minister of State Security, the applicant also requested the Minister to furnish him with a variety of documents. I have already referred to the applicant's attorney's letter of 5 August 2020, and indeed I've referred to the response of the Acting Director General to that letter. On the 14th August 2020, the applicant's attorneys appeared to have written a letter to me as the chairperson of the Commission, requesting that I help by persuading the President, the Minister of State Security, the Inspector General, and the Director General of the State Security Agency to comply with his request for information. The applicant or his attorneys did not respond to the letter from the Acting Director General of September 2020, to which a reference has been made above. This was still the case by the 9th March 2021, when the applicant lodged his application for an order compelling the State Security Agency to furnish him with the documents he had asked for. However, there are 2 or 3 letters that the then applicant's attorney wrote in the second half of 2020 and early in 2021, suggesting that they were still pursuing the idea of obtaining documents from the State Security Agency. These have been dealt with in the previous paragraph. By way of a letter dated 23 January 2021, addressed to the then Acting Director General, Mr. Loiso Jafta, once again, the applicant's attorney requested the declassification of various documents. No reference was made to the letter of September 2020 from the Acting Director General to the applicant's attorney, in which the Acting Director General had extended an invitation to the applicant to meet with him to discuss his request for documents. On the 9th of March 2021, the applicant lodged his application with the Secretary, that is his application for an order compelling the Minister of State Security, the Director General of State Security Agency, and the State Security Agency to furnish him with various documents. That is, he lodged his application with the Secretary of the Commission. In his affidavit in that application, the applicant stated that he needed the documents in order to complete his statement to the Commission. In paragraph 18 of his founding affidavit, the applicant said, and I quote, "These documents are necessary to enable me to respond to the allegations leveled against me and assist the Commission uncover the true nature and extent of state capture, and I'm convinced that the respondents are in possession thereof." In the next paragraph in his affidavit, the applicant said that up to that date, the respondents in that application, which would include the Acting Director General of the State Security Agency, had, and I quote, ignored, failed, and or refused to provide, close quotes, him with intelligence, documents, and or information that he had requested. He said that they had not provided him with any reasons for their failure or refusal to comply with the request. On the 17th of March 2021, the answering affidavit of the Acting Director General, who by now was Mr. Ambassador Tony Msimanga of the State Security Agency, was lodged with the Commission and would have been served more or less around that date on the applicant's attorneys. The answering affidavit was deposed to by Mr. Msimanga, but a confirmatory affidavit of Mr. Loiso Jafta, who had been the Acting Director General earlier in the year and in 2020 or part of 2020, was also filed. In the answering affidavit, Mr. Msimanga complained that the applicant had failed to give adequate details of the information or documents he was requesting, with the result that the State Security Agency could not determine which documents exactly he wanted. He also complained that the information that the applicant had provided made it difficult to determine the relevance of some of the information or documents to the work of the Commission. In paragraphs 14, 15, and 16 of his affidavit, Mr. Msimanga said the following, which I consider very important. And I quote, paragraph 14, "However, in my capacity as Acting Director General, I'm willing to cooperate with and where possible provide the applicant with documents that are considered relevant to the Commission's scope of work and which may enable him to address the Commission with regard to allegations that were made against him in the Commission. To this end, I'm willing, acting in the best interests of the agency and the Commission, to afford the applicant access to the relevant files and or documents. This may take place, that is paragraph 15, this may take place in the form of the applicant's visit to the premises of the agency, where he would be allowed access and perusal of the documents under supervision, during which process he will be required to specify precisely which documents he would like to be declassified. Such documents may only be those that are relevant to the Commission's scope of work and or which are relevant to the allegations that were made against him in the Commission, which as such will enable him to refute such allegations. 16. Such process will have to be in compliance with the provisions of Chapter 24 of the regulations in terms of the Intelligence Services Act 65 of 2002. This process will then be followed by the official internal processes in relation to the consideration of the applicant's need for declassification and the manner in which such documents or information would be made available to him, which would include reduction of sensitive information if necessary, or if necessary, the prescribed process may be expedited, close quotes. On the 13th April 2021, the applicant deposed to a replying affidavit to Mr. Msimanga's affidavit. In paragraph 5 of his replying affidavit, this is what the applicant said about the contents of paragraphs 14, 15, and 16 of Mr. Msimanga's affidavit, and I quote, "The purpose of this affidavit is to set out the basis upon which I submit that the documents are relevant to the allegations raised by certain witnesses against me. In doing so, I will accept the offer made by the SSA in paragraphs 14, 15, and 16 of its answering affidavit. Furthermore, and in view of the time constraints facing the Commission, I will request that the Chairperson sets out a clear time frame within which such documents must be declassified and furnished to me." Close quotes. It is clear from this paragraph in the applicant's replying affidavit that he completely, unequivocally, and unconditionally accepted the offer made by Mr. Msimanga and the State Security Agency, including the requirement for him to have access to the documents and information that he required, that there would have to be compliance with Chapter 24 of the regulations made under the Intelligence Services Act 65 of 2002. I note that in paragraph 10 of his replying affidavit, the applicant said, among other things, "I have cast the net wide." Let me start that. I quote, "I have cast the net wide because the testimonies of Mufamadi, Njenje, Makatuga, Jafta, and Miss K all sought to attribute all intelligence failures to me and my tenure. I stress that my statement is incomplete without the documents I seek. As a courtesy, I've elected to attach it in its current state in order to demonstrate that I seek to assist the Commission and await these documents in order to complete the picture painted in my draft statement." Close quotes. Paragraph 17 of Mr. Msimanga's answering affidavit is also important. It It is the paragraph that comes immediately after the three paragraphs to which the applicant referred in his replying affidavit in Mr. Msimanga's affidavit. Accordingly, the applicant could not have missed paragraph 17. In that paragraph, Mr. Msimanga refers to the letter dated 23 August 2020, but sent on 21 September 2020 by his predecessor, Mr. Loiso Jafta, to the applicant's attorneys in response to their letter, first letter to him, that is the letter of 5 August 2020, in which they requested the SSA to give the applicant the documents that he said he needed. In paragraph 17 of his affidavit, Mr. Msimanga says, and I quote, "I am advised that Mr. Jafta, in a written response to the applicant's attorney's letter to the Office of the Director General of the agency, dated 5 August 2020, advised and invited the applicant to follow the appropriate procedure to enable the agency to properly consider his request for information. In the said letter, dated 23 August 2020, which was sent to the applicant's attorneys on 21 September 2020, Mr. Jafta also extended an invitation to the applicant for consultation with him to discuss how best the matter could be dealt with. However, this advice and invitation came to naught as the applicant did not follow the said advice and ignored the invitation. A copy of the aforesaid letter from Mr. Jafta to the applicant is attached hereto and is marked Annexure TM1. The Chapter 24 regulation attached to the said letter is annexed hereto and is marked Annexure TM2. Proof of dispatch of the said letter by email on 21 September 2020 is attached hereto and is marked Annexure TM3. Close quotes. Paragraph 17 of Mr. Msimanga's affidavit is clear. What is very interesting is that in his replying affidavit, the applicant, who must have read paragraph 17, did not deny what was said in paragraph 17, nor did he deny that he or his attorney received Mr. Jafta's letter, which is referred to in paragraph 17. This has to mean that the applicant's attorneys did receive that email or letter and the applicant knew about it. This has to be so because there can be no doubt that if the applicant's attorneys had not received the letter or email, the applicant would have said so in his response in the replying affidavit after reading paragraph 17 of Mr. Msimanga's affidavit. The fact that he did not deny the contents of paragraph 17 means that he and his attorneys did receive the email or letter. The question that arises if the applicant and his attorneys at the time did receive Mr. Jafta's letter is this one. Why did the applicant's attorneys then, or the applicant, not respond to it and accept Mr. Jafta's invitation and meet with Mr. Jafta and do the necessary to obtain the documents that the applicant had requested? The applicant did not explain this in his replying affidavit. Another question is this: why did the applicant write other letters to the Acting Director General requesting the documents? This is not explained. Yet another question is, why did the applicant launch an application in the Commission for an order compelling the Minister of State, Security, the Acting Director General of SSA, and SSA to give him documents that he knew they had said they were prepared to give him if they were relevant to the work of the Commission or related to allegations that had been made against him in the Commission if he complied with Chapter 24 of the regulations in terms of the Intelligence Services Act of 2002. This is difficult to understand. However, these are not the only unanswered questions relating to the applicant's application. There are more unanswered questions. On the 14th April 2021, when the applicant's application for an order compelling the SSA to give him documents was to be heard, an agreement was reached that the application be adjourned sine die to enable the applicant or his legal representative and the State Security Agency to meet with the SSA and seek to reach an agreement on which documents the SSA would be prepared to give him and which documents they were not prepared to give him, if any, and what the grounds were for their unpreparedness to give him some of the documents. The transcript of the 14th April, the transcript of the proceedings of the Commission on the 14th April 2021 was furnished to the applicant, and he was given an opportunity to comment thereon, and he has not disputed the contents of the transcript. They reveal that the applicant's own legal representative said the following, among other things, during those proceedings, and I quote, "And for the first time in the respondent's answering affidavit, do we get told that the respondents are willing to assist us with the documents that you require and subject to us providing them with the particulars of the documents that are required," close quotes. Indeed, the applicant's legal representative is reflected in this transcript to have also said, and I quote, "Our view then, which we indicated to our opponents, is that to the extent that they undertook to provide us with documents, provided that we give them the particularities, we have done that. As far as we are concerned, there is no matter to be argued anymore today," close quotes. What the applicant's attorneys or counsel was saying was, in effect, that an agreement had been reached between the parties in terms of which the applicant's side needed to give the State Security Agency particulars of the documents they wanted the State Security Agency to make available to them. It was in this context that he then said that as far as he was concerned, there was no longer any matter to be argued that day. The transcript then reflects that I had this to say to Mr. Fraser's legal representative, that is to the applicant's legal representative. And I quote, "As it stands, well, it seems to me that because they have given that undertaking, you are right in taking the attitude that you should give them time to apply their minds to the particulars that you have given so that they can give you the information you have asked for. Or if they have reason not to give some of the information that is, they can tell you why. But it seems that there is no point in pursuing the application as of today. It may well be that the application should be postponed either to a specific date or sine die, so So that stays the one point. But the other point, which I must say, is that you and your client appreciate the situation, must appreciate the situation that the commission is faced with, and I'm just making sure that this sentence is legible, is understandable. That is to what the commission can do at the time that your client will have received the documents. That is looking for in terms of the commission allocating any time for any evidence. I cannot give you any guarantee because of precisely where we are. The oral evidence should have been finalized by the end of March. We are in extra time and there is serious difficulty. You know, April and May and June were supposed to be for the writing of the report. So I'm just mentioning that for what it is worth, so that as and when you reach a point where you have got the information you are asking for, we are not guaranteeing anything. If at that stage you make a request to give evidence or whatever, that will have to be looked at that time against the constraints that will exist at that time. You appreciate that. Close quotes. It will be seen from what is quoted above that Mr. Fraser's legal representative was specifically informed that because of the time when the applicant brought his application, there was no guarantee that when he obtained the documents he sought, the commission would be able to hear his evidence or that of any witnesses he might wish to call. It was made clear that the hearing of oral evidence was meant to have been completed by the end of April. The applicant's legal representative was asked whether he appreciated the constraints under which the commission was operating, and he responded, and I quote, "We appreciate that, Chairperson," close quotes. The transcript also reflects what the respondent's legal representative said in those proceedings. He is reflected as having said, and I quote, "The agency was approached by the applicant as early as August 2020. The then Acting Director General responded to the applicant, inviting him to follow the correct procedure and also invited him to have a consultation with him so that they can see how best the agency can help him to expedite the issue of the disclosure of information." And that was the letter to the applicant that was sent on the 21st September 2020. And the applicant did not respond to the invitation that was extended to him by the then Director General. And now, 6 months down the line, they decided to approach the commission, alleging that they would not have been afforded an opportunity to get the documents that they are looking for, which is not true, close quotes. The State Security Agency's counsel in that application submitted that Mr. Fraser was wasting the Commission's time and abusing the Commission's processes, and his application should simply be dismissed. The transcript reflects that at that stage, the chairperson suggested that Mr. Fraser's application be postponed to enable the parties to try and reach an agreement, and the respondent's legal representative then decided not to persist in his argument that Mr. Fraser's application be dismissed. The transcript also reflects something important that Advocate P.J. Pretorius SC, the head of the Commission's legal team, said in those proceedings. Mr. Pretorius is reflected as having said, among other things, and I quote, Mr. Fraser says in paragraph 34 of his founding affidavit, "I'm more than eager to expose the machinations of these people who I believe are guilty of abusing their positions in government to favor and unlawfully enrich themselves. their friends and or associates to favor or disadvantage certain political parties and factions of political parties, steal from the public purse, and then there is an allegation that I'm going to deal with. Chair, that is now Mr. Pretorius, there are two ways that this will be dealt with, this issue. The Commission's powers to order the production of documents are there for the Commission to conduct its own investigations in terms of its own terms of reference. Mr. Fraser appears on his own statement to have evidence significant to the work of the Commission, and from the legal team's point of view, of course, and I'm sure that will be endorsed by the investigators, we invite Mr. Fraser to come and cooperate with the Commission's investigators so that the Commission can, with Mr. Fraser, conduct an investigation. What is happening here is that an investigation is being conducted outside the ambit of the Commission's work. So, if Mr. Fraser has evidence relevant to the Commission of this nature and of a serious criminal, I'm going to start that sentence. So if Mr. Fraser has evidence relevant to the Commission, evidence of a serious criminal nature, it should have been brought before the Commission long ago. But although it is late, we invite Mr. Fraser to work with the Commission in a Commission investigation, close quotes. This part of the transcript reflects quite clearly that the head of the Commission's legal team publicly invited the applicant, I open quotes, to come and cooperate with the Commission's investigators so that the Commission can, with Mr. Fraser, conduct an investigation, close quotes. Later, Mr. Pretorius is reflected as having said, and I quote again, we invite Mr. Fraser to work with the Commission in a Commission investigation, close quotes. The applicant's legal representative did not accept Mr. Pretorius' invitation in those proceedings. The applicant's application relating to documents was adjourned sine die on the basis that he or his legal representatives would meet with SSA and agree on the documents that if he did not find satisfaction, he could come back to the Commission and ask that the Chairperson decide his application and compel the respondents, that is the State Security Agency and the Acting Director General in that matter, to give the documents he wanted, to give him the documents he wanted in order to complete his statement to the Commission. About 2 months later, that is on the 17th June 2021, the Commission's Secretariat wrote to the applicant's attorneys and to the Director General of SSA and called upon them to report back to the Commission on what was happening with regard to the applicant's application relating to documents. It would appear that the applicant's attorneys did not respond, but the state attorney responded on behalf of the State Security Agency. The state attorneys did so by way of a letter dated 22 June 2021. It is not necessary to quote the contents of that letter. It is sufficient to say that the State Security Agency seems to have genuinely tried to have the matter expedited, but no meeting took place. However, the most important point that is made in the letter is that an agreement had been reached between both sides on the minimum requirement that the applicant was to comply with, but he had failed to comply with that requirement. And until he had complied with that requirement, the State Security Agency, according to the state attorney, could not do much about his request for documents. The agreement that the state security agency, the state attorney was referring to in the letter must be the agreement that had been reached between the applicant and the state security agency in the agreement that was reached in the proceedings of the Commission on the 14th April 2021. In paragraph 8 of the state attorney's letter referred to above, the state attorney said the following, among others, and I quote, "Lastly, we consider it apposite to emphasize that it is our client's view that Mr. Fraser, as a former Director General of the agency, is well aware of what the provisions of the said regulations entail, including the importance of compliance therewith. It is therefore inconceivable that the delay in holding the said meeting could ever be a stumbling block in the submission of Mr. Fraser's request for information in accordance with the correct procedure as stipulated in the regulations. The applicant's action in failing to comply with the regulations is considered strange, as in a letter to the Commission dated 13 April 2021, the applicant, through his attorneys, expressly stated that he was in agreement with our client's submission as contained in the answering affidavit, which inter alia emphasized the need for the applicant to comply with the regulations. A copy of the letter from the applicant's attorneys in this regard is attached here to marked Annexure C to these quotes. The applicant has been afforded an opportunity by the Commission to deal with the contents of the letter from the state attorney and share with the Commission his version on what happened after 14 April 2021 with regard to the purpose for which his application relating to documents had been adjourned. But he has not placed anything before me that shows that he acted diligently to try and secure from the State Security Agency the documents that he had said he needed in order to complete his statement before the Commission. The applicant has been afforded the opportunity by the Commission to explain why he has not complied with the regulations with which he knows he needs to comply if he seeks to be furnished by the State Security Agency with the documents that he seeks in order to complete his statement. On what is before me, the reason why the applicant has not been furnished with the documents that he said he wanted from the State Security Agency is that he has failed to comply with the regulations that he had agreed to comply with, and he has failed to do what is necessary for him to do in order to obtain the documents. He has not acted on the agreement that was reached between him and the State Security Agency when in his replying affidavit he said that he accepted the offer contained in paragraphs 14, 15 and 16 of Mr. Msimanga's affidavit. He has also not explained why he did not do so. Furthermore, the applicant has never come back to the Commission to report on the outcome of a process that was agreed upon in the Commission on 14 April 2021. He has left the Commission unsure of what is going on. The applicant has done this in circumstances where he knew that on the 14th April 2021 was when his application came before the Commission. He was told that because of how late he had brought his application for an order compelling the State Security Agency to give him the documents he wanted, there was no guarantee that if and when he got those documents, the Commission would be able to hear oral evidence. One would have thought that anyone who was genuine about giving evidence or about being able to get a date or dates to cross-examine witnesses who had implicated him in wrongdoing, would do everything in his or her power to expedite the matter and to keep the Commission informed of how the process of obtaining the documents was progressing, not the applicant. By the end of May 2021, the applicant had not told the Commission anything. By mid-June, the applicant has still not told the Commission anything. When the Commission wrote to him or via his attorney, he did not respond. Only the state attorney responded. By the end of July 2021, the applicant had still not told the Commission what was happening. Indeed, even now, the applicant has not told the Commission what happened with the execution of the agreement that he and the state security agents had reached, as recorded in his replying affidavit in response to the answering affidavit by Mr. Msimang. The State Security Agency has said the applicant was obliged to comply with Chapter 24 of the regulations but has not complied. The applicant has not said that he has complied with that requirement. So the position must be that the applicant stopped seeking the documents he had said he needed, but has not told the Commission why he stopped and how his version would now be complete without the documents when he had said that it would not be complete without the documents. Why the applicant did not cooperate with the State Security Agency as he had agreed to in order to obtain the documents he had said he needed is another unanswered question in the applicant's application. With that background, it is necessary to then look at the rules of the Commission that govern proceedings or applications for leave to cross-examine a witness. Regulation 15 of the regulations of the Commission provides that the Commission may prescribe its own processes. Rule 3 of the rules of the Commission governs witnesses who are presented to the Commission by the Commission's legal team and implicated person and their evidence. Rule 33 of the rules of the Commission make it clear that if an implicated person wishes to give evidence himself or herself, or to call a witness to give evidence on his or her behalf, or to cross-examine a witness, he or she must, within 2 weeks from the date of notice, apply in writing to the Commission for leave to do so, and the chairperson will decide the application. Rule 3.4 is also very important. It reads, and I quote, an application in terms of Rule 3.3.6 above must be submitted in writing to the Secretary of the Commission within 14 calendar days from the date of the notice referred to in Rule 3.3. The application must be accompanied by a statement from the implicated person responding to the witness's statement insofar as it implicates him or her. The statement must make it clear what parts of the witness statement are disputed or denied and the grounds upon which those parts are disputed or denied. I draw attention to that part of Rule 3.4, which requires an implicated person who applies for leave to cross-examine a witness to ensure that his or her application is, and I quote, accompanied by a statement from the implicated person responding to the witness's statement insofar as it relates to him or her, close quotes. I also draw attention to the sentence that follows that sentence. It obliges the implicated person who makes an application for leave to cross-examine to ensure that his or her application, open quotes, makes it clear what parts of the witness statement are disputed or denied and the grounds upon which those parts are disputed or denied, close quotes. I've made it clear in previous rulings that Rule 3.4 requires an applicant for leave to cross-examine to furnish his or her full version in regard to incidents or matters dealt with in a witness statement or affidavit. In other words, the principle is that an implicated person cannot be expected to be granted leave to cross-examine a witness who has implicated him or her unless he or she makes a full disclosure of what his or her version is on the matters or incidents in issue. The reason for this is clear. In proceedings of a body such as a commission of inquiry like this one, an implicated person cannot be allowed to use cross-examination without taking the commission into his or her own confidence and telling it what he or she knows about matters which it is investigating, of which he or she has knowledge. Another reason why this rule obliges an applicant for leave to cross-examine to make a full disclosure of his or her version is to enable me as the chairperson of the commission to determine how much is in dispute between the version of the witness and the version of the implicated person, how important the points of dispute are between them to the matters being investigated by the commission, and how much time need to be set aside for the cross-examination of the witness if leave to cross-examine is granted. This is important because if I know where the points of dispute are between the implicated person and the witness, I'll be able to direct that cross-examination should focus on the points in dispute between the two versions. That would ensure that time is not wasted by the implicated person or his or her lawyer putting questions to the witness that relate to points that are not in dispute. Rules 3.5, 3.6, and 3.7 are also important. They read, and I quote, "If an implicated person believes that the Commission's legal team did not give him or her the notice referred to in Rule 3.3 within a reasonable time before the witness could or was to give evidence, and that this may be prejudicial to him or her, he or she may apply to the Commission for such order as will ensure that he or she is not seriously prejudiced." 3.6. In deciding an application contemplated in Rule 3.3.6, the chairperson may, in his discretion and on such terms and conditions as he may deem appropriate, grant leave to an implicated person to give evidence, that is A, B, to call a witness to give evidence on his behalf, and or C, to cross-examine the witness implicating him. 3.7. In accordance with Regulation 8.3, there is no right to cross-examine a witness before the Commission, but the chairperson may permit cross-examination should he deem it necessary and in the best interest of the work of the Commission. Rule 3.5 seeks to provide a remedy to an implicated person who complains that he or she was not given a Rule 3.3 notice timelessly and that this would prejudice him. The applicant in this case did not invoke this rule to ask for any remedy. Rules 3.6 and Rule 3.7 provides that I have a discretion to grant leave to cross-examine and that I may grant it if I deem it to be in the interest of the work of the Commission to do so. With that discussion of the rules out of the way, it is important then to have regard to the applicant's application. As I indicated earlier, the applicant's application for leave to cross-examine consisted of a notice of motion and a founding affidavit, as well as two unsigned statements, two statements that were unsigned, and the applicant's own application relating to documents that I've referred to earlier, which was launched on the 9th of March 2021. That application was an annexure to one of the unsigned statements. Statements that I've said were unsigned, were also not under oath. The applicant indicated in his affidavit that they were not signed because he was waiting for the documents that he had asked for, and he would then complete his statement once the documents had been received. I've referred earlier to the names of witnesses that the applicant wanted to or sought leave to cross-examine, and in his affidavit that he furnished to the Commission in support of his application, he dealt with four of those witnesses, and he said in the same paragraphs that they had implicated him in four broad areas, and those are Ambassador Makletuga, Mr. Sheikh, Mr. Njenje, and Dr. Mufamati. So he set out in paragraph 15, 16, and onward various areas where he said they had implicated him in their affidavits or evidence. But he did not specify in which parts of their affidavits, respective affidavits, they had implicated him. In paragraph 16, he simply said the four broad areas were the following. One, the 2006 National Intelligence Agency, in brackets NIA, Principal Agent Network, PEN program, was a corruption scheme. He said that is what they implicated him in. He said they also implicated him in the centralization of power in relation to the 2006 NIA PEN and the Strategic Development Plan, Vision 2035, in brackets SDP. He said also they implicated him in governance matters of the SSA during his time. He said they implicated him also in doctrinal shift away from what was conceived in 1994, resulting in the unlawful repurposing of the SSA. He said another issue raised by Ambassador Makletuga and others, which directly or indirectly affected him, was the investigations that were conducted into the affairs and operations of the 2009-2006 NIA PEN program. In paragraph 19, he said at the outset, I refute these allegations as utterly without any merit. He continued, and I quote, I refer the Commission to the version set out in Annexure AF1 and AF2, wherein I deal with the testimony of Makletuga and others. As I demonstrate below, my version of the legislative framework is contrary to that given by the 2009 State Security Agency's top three officials, in brackets Makletuga, Sheikh and Janja, close brackets, and Dr. Mofamati in their testimonies. What the applicant did not do in his affidavit in relation to his application for leave to cross-examine these 4 witnesses is that he did not take each one's affidavit, tell the commission in which paragraph that witness implicated him and by what statements of evidence. And then he did not then deal with that. That is what would be required, and that is what is well known among all legal practitioners you do when you respond to an affidavit. You identify the paragraphs that are important or that you dispute, or the paragraphs on which you have something to say, particularly those you dispute, and you say what parts of those paragraphs you dispute completely, what parts you admit, what parts you qualify, or what parts require context. What he has done is, that is the applicant, simply to say these are the broad areas in which these witnesses have implicated me, and I refute the allegations they made against me as without any merit. He has something to say in terms of some of the points that he says, or areas that he says they implicated him in. And then, as I've indicated, he also says his version is contained in Annexure AF1 and AF2. Those are the unsigned statements that I talked about earlier, which on his own, by his own admission, do not contain his complete version. They should have been signed, and they should have been under oath, but they are not. The applicant deals in his affidavit with certain topics such as the 2006 National Intelligence Agency Principal Agent Network and Program, intelligence and its role in society in relation to national security is another topic he deals with in his affidavit. The politicization of SSA is another topic that he deals with, and governance matters that he deals with, as well as the Strategic Development Plan Vision 2020-2035. It would appear that it deals with those topics in relation to the 4 witnesses that I have indicated, namely Ambassador Makretuga, Mr. Njenje, Mr. Sheikh, and Dr. Mofamati. He also indicated that he sought leave to cross-examine Mr. Jafta, the former acting Director General of SSA, and in paragraph 4 or 41 of his affidavit, he says, and I quote, "Although I did not receive a Rule 3.3 notice in respect of Jafta's testimony, I've considered his statement and testimony before the Commission. In his statement, he implicates me by alleging the following. 41.1, in paragraph 11 of his statement, he falsely accused me of centralization and over-concentration of power in my office. He further alleges that I systematically subverted the law and systems of control within the agency by unlawful also claims that I irregularly approved funding for ulterior purposes and undermined reporting procedures of the agency. For 41.4, more seriously, he alleges that a sum of 125 million rand was unaccounted for and emanates from operations in the Office of the Director General during my tenure. 41.5, confirming the report of the high-level review panel on the SSA and the testimony of Dr. Hamadi, he claims that an amount of 9 billion rand in relation to assets was unaccounted for, close quotes. I pause here to say that the reference to 9 billion rand was clarified in the commission and it was accepted, as I recall, even by Mr. Jafta, that amount was incorrect. The applicant then says in paragraph 42, the above claims are false and reveal a misunderstanding of the applicable legislative framework and internal procedures. My version, as reflected in AF1 and AF2, and in my affidavit to the SAPS under Hillbrow, CAS 2/02/2021, a copy of which is hereto attached as A4, demonstrates that the above claims are without merit. Close quotes. Except for the reference to paragraph 11 of Mr. Jafta's affidavit, it is not indicated anywhere else where all these other allegations are made in Mr. Jafta's affidavit that the applicant says implicate him, that he wants to cross-examine him on. He says in paragraph 43, I wish to cross-examine him, that is Mr. Jafta, on the following themes. 43.1, the correct legislative framework in respect of the powers of the Director General as the accounting officer. 43.2, his claims that large sums of money were utilized by me in conflict with the applicable procedures and mandate. 43.3, his claim that during my tenure I abused my powers in the manner in which I dealt with resources and staff. And 43.4, issues related to governance. With regard to Mr. Y, the applicant says he received a Regulation 33 notice in respect of Mr. Y on 8 January 2021 and was advised of the broad areas in which Mr. Y implicated him. He then goes on to set out those areas as he understands them in paragraph 44.1 to 44.5. He then says that his own version is reflected in annexures AF1, AF2, and AF4. Emphasize that these annexures AF1, AF2 are lengthy statements. What it means is that the applicant requires me to go to those lengthy statements and try and look for paragraphs where the particular witness makes allegations against him and look back at his affidavit and see whether that is one that he's talking about in his application, try and understand what his version is and whether he disputes the whole paragraph or parts of the paragraph, or he explains some of the context which the witness might not have given. That is not how affidavits, when you respond to another affidavit, are supposed to be done. You are supposed to take each paragraph challenge in the affidavit of the person who implicates you in wrongdoing, and deal with it clearly so that it is clear what parts of the affidavit and what parts of each paragraph you admit or which parts you dispute. The applicant has not done that. The applicant has also referred to the Rule 3.3 notice in respect of that he received in respect of Dr. Dintwe, and he says that the applicant or Dr. Dintwe implicates him in the following. One, and I read from his affidavit, he, that is now Dr. Dintwe, alleges that during my tenure as Director General of the Free State Security Agency, I lacked the requisite understanding of the powers of my office vis-a-vis that of the Office of the Inspector General of Intelligence. 46.2, he alleges further that I exhibited a contemptuous and recalcitrant attitude towards the OIGI and that I undermined its work. 46.3, he further alleges that I assisted the then Minister of State Security, Mr. Bongani Bongo, to reduce the powers of the Inspector General of Intelligence and to remove him from office. 46.4, lastly, he alleges that the manner in which I dealt with vetting was contrary to the provisions of the requisite legal instruments and legislative framework. In paragraph 47, he then says, I hereby apply to cross-examine him on the above stated aspects and to put to him the version contained in AF1. To the extent that Dintwe ventures into the legislative framework and alleges that I misunderstood my powers, my version may be summarized as follows. The legislation states that the Director General of the SSA is empowered in law to issue the security clearance of the Inspector General of Intelligence, IGI. Consequently, the Director General is also empowered to withdraw the security clearance of the IGI. 47.2, the IGI is required to comply with all security requirements applicable to all the employees of the SSA. In fact, the IGI previously abandoned the litigation in which he attempted to make similar inaccurate and spurious allegations. There is no reference, that is 47.3, in Dintwe's claim to any fact supporting his claim that I abused my powers in any way whatsoever. Instead, it reveals in his allegations his own misconception of the applicable legislation. And then he concludes his application. Counsel for the applicant submitted in his written submissions that the applicant had complied with the requirements of Rule 3.3 and 3.4, the rules relating to applications for leave to cross-examine witnesses. I did consider the written submissions that he submitted, but as I've indicated, I'm satisfied that the applicant did not comply with the requirements of the rule in the way in which I have indicated. The applicant needed to have identified exactly what parts of the affidavits of the witnesses he implicated him and which ones he disputed and which ones he did not dispute, and he needed to have given a full version of his side of the story in regard to all the allegations. I indicated earlier on that I have made rulings before in relation to applications for leave to cross-examine in which I've indicated that the rules require that an applicant for leave to cross-examine a witness is required to furnish the commission with his full version or account of the events that he is implicated in. In this case, one, the applicant has not complied with the rule in relation to identifying in the affidavits of the witnesses exactly the paragraphs and parts of paragraphs that he disputes and which implicate him and what his version is in regard to that. But two, he has, on his own admission, said that his version is incomplete without the documents that he sought to obtain from the State Security Agency. The Commission adjourned his application on the 14th of April in order to give him and the State Security Agency an opportunity to discuss and reach agreement on the documents that could be made available to him, because quite clearly the State Security Agency was prepared to give him documents if they were relevant to the scope of the commission or relevant to the allegations that had been made against him in the commission, and if it could do so without being in breach of the law. It is quite clear that they agreed as to what should happen, and that included compliance with Chapter 24 of the regulations promulgated under the Intelligence Services Act of 2002. The State Security Agency says he has not complied with that. In order to get the documents that he contends he is entitled to get, he has not explained why he has not done so in circumstances where he told this commission on affidavit that those documents that he sought were very important in order for him to complete his statement and to give this commission a complete picture. In those circumstances, I can see no reason why it can be said that it is in the interest of the work of the commission to grant the applicant leave to cross-examine any of these witnesses in the circumstances that I have set out in relation to non-compliance with the rules of the commission, and in relation to there being no explanation as to why, having said that his statement would not be complete without the documents that he asked for from the State Security Agency, and the commission having given him time to ensure that he secured such documents, and the State Security Agents having undertaken to give him such documents, why he has not pursued that and why he is no longer seeking to place those before the commission so that his statement before the commission is complete. In all of these circumstances, I've concluded that the applicant's application stands to be dismissed, and it is so dismissed.
Noted. Thanks, DCJ.
What adjourns? The commission adjourns.